The full horror of abortion was before the Supreme Court yesterday. And interestingly, faced with it, the leftists standing before the court, I'm talking about Elizabeth Prelogar, the Solicitor General speaking for the Biden administration, also the woman, Julie Reicherman, I believe her name is, representing the abortion clinics, they flinched. They didn't want to talk about abortion. And I can see why, because it's really not a pretty thing to want to kill your kid. And this is really what abortion is all about in the simplest terms. This is a horror that's been recognized for centuries throughout the West. I've talked on the podcast about Macbeth. Let me read a line that Shakespeare put into the mouth of Lady Macbeth, really to show the villainy of her mind. Now, she's trying to talk to Macbeth to bully him into murdering King Duncan. And she says this: I have suckled a baby, and I know how sweet it is to love the baby at my breast. But even as the baby was smiling up at me, I would have plucked my nipple out of its mouth and smashed its brains out against the wall if I had sworn to do that the same way you have sworn to do this. So she's like, I am more resolute than you are, to the point that I would kill my own kid. And for Shakespeare, there's really no crime worse than this. And this is abortion. In some ways, I would concede abortion is the debris of the sexual revolution. If you're going to have a sexual revolution, you're going to have unwanted pregnancies. And so from the left's point of view, this is a price worth paying. If you have unwanted pregnancies, you should be able to get rid of the kids that you made. Now, I was kind of, way chuckling, but also poignantly watching these women standing in front of the court, and they were like popping abortion pills left and right. And I guess their point is, we don't want to reproduce. And looking at them, I was like, yeah, I don't want you to reproduce either. But nevertheless, this was a grim and disgusting sight. This would almost be like the gas chamber lobby out there. We gotta have gas chambers. We gotta have gas chambers. There's a social value in gas chambers. Now, Clarence Thomas got to the heart of the matter very succinctly with his customary clarity, where he said, hey, where is this abortion right in the Constitution? I'm quoting Clarence Thomas. If we're talking about the Second Amendment, I know exactly what we're talking about. If we're talking about the Fourth Amendment, I know what we're talking about because it's written. It's there. Where specifically is the right here that we're talking about? And of course, the pro-choicers were like, emitting this squid-like cloud of obfuscation. Well, it's the right to liberty. And Thomas's point is that there is no enumerated, specified right to abortion in the Constitution. End of story. Now, the left knows that they've got a problem here. They're defending a fictional right. At one point, Sotomayor tried to save the day by jumping in and saying something like, well, there are lots of rights that aren't in the Constitution. And the point is, maybe there are, but it's not the Supreme Court's job to enforce them. The Supreme Court's job is to enforce the Constitution as the highest law, not to make up rights that aren't in the Constitution, kind of read them into the Constitution. I mean, this would be interpretive malpractice. Now, the pro-choice side, kind of recognizing the problem that they have, decided to defend abortion, not really by defending the act, not by defending its necessity, but rather by defending the idea of precedent. Precedent in Latin is stare decisis, the idea that we should sort of leave things as they are. And the argument for precedent, I have to say, is kind of a conservative one. Many years ago, I heard a conservative kind of vehemently defend the idea that institutions, even if you don't know their underlying rationale, should not be questioned. And his argument was that if an institution has survived for a long time, in his case, he meant hundreds of years, there must be some underlying rationale for it, even if that rationale is not apparent, and therefore an institution purely on the view of its durability deserves a measure of respect. And I was standing there in the company of a professor of mine, and the professor destroyed this argument in one sentence by saying, what about anti-Semitism? Anti-Semitism is a tradition. It's been around for a long time. Does it deserve presumptive respect? So the point being here that there are good and bad traditions. And so precedent never becomes an argument that stands all by itself. This was a point, by the way, that Justice Kavanaugh made is he basically said, let me recite to you a series of precedents. The most famous, he mentioned, Baker versus Carr, which has set the stage for one man, one vote. He mentioned Miranda versus Arizona, which overturned the previous Supreme Court decision, basically said, listen, you have to give a Miranda warning. You have to let people know they have a right to remain silent. They have a right to have an attorney present when it's a criminal case. And most famously, he mentioned Plessy versus Ferguson. This was the precedent that upheld segregation for 70 years, 60 years before it was overturned by Brown v. Board of Education. And Kavanaugh quite simply said, well, listen, if a precedent is wrong, as we recognize Plessy to be wrong, why would you keep it intact? And this was really a problem for the pro-choice side. They basically tried to say that precedents deserve a kind of automatic deference. There needs to be, quote, new information to overturn a precedent. And of course, in the Plessy case, there was no new information. Now, interestingly, in the abortion case, which we're talking about here, there is new information. First of all, the point of viability has moved forward. Second of all, there are massive advances in technology that allow us to observe the fetus inside the womb, to recognize that even though it is by a cord attached to the mother, it is nevertheless a distinct human being with, if it's part of the mother, then what are you saying? You've got a mother that has basically 20 toes? And 4 eyes, and 4 ears. No, the fetus has its own ears and has its own eyes, its own organs, its own brain, its own heartbeat. So this is, in fact, if not new information, at least information that is now present with a sort of clarity that wasn't there before. Even the issue of viability has completely changed. It's much easier for fetuses to live outside the womb at a much earlier stage of pregnancy. And one of the justices, I think it was Alito, who made a very good point. He basically said, listen, you keep talking to me about the women's interest in not having a pregnancy. He goes, well, that's not changed whether it's before or after viability. If the woman finds the kid to be an inconvenience, I don't want to have it, I want nothing to do with it, then you want nothing to do with it when it's 2 months in the womb, and you want nothing to do with it when it's 8 months in the womb. Viability makes no difference at all. This was actually a fascinating exercise in watching how the center of gravity in the Supreme Court has shifted. In fact, Roberts is no longer the swing vote. Roberts appears to be in the position where he wants to uphold the Mississippi law, but at the same time maybe preserve Roe intact. But what's interesting is that the other 5 conservatives seem to have no interest in this, quote, compromise. This, quote, compromise position, I think, may not end up being where the court goes with this. And what I hope the court does, I'm going to have my daughter, Dinesh D'Souza to talk about this in the next segment to kind of analyze what happened in this hearing further. Well, what I hope the court decides to do is not merely to uphold the Mississippi law, but simultaneously to terminate Roe v. Wade.